and want to listen again, you can get to it that way.
So let me introduce Joseph Cobert. Joe has been practicing California real property law since 1975 with a California real estate broker's license since 79. He is known for expertise in both transactional and litigation in all matters involving real estate. He has represented clients to a successful outcome in numerous real estate lawsuits, many with millions of dollars at stake. He also has produced optimal outcomes in negotiations and prepared documentation for a wide range of real property deals. Also, because of his active role in representing the industry on pending legislation, as well as speaking at seminars and conferences, Joe has helped professionals and investors alike to keep them well informed. For over 30 years, he taught a UCLA Extension real estate finance course, which has helped hundreds of folks educate and prepare real estate professionals and investors for a wide variety of legal and practical matters. He was the former association of an apartment association. He was with the Urban Land Institute, which deals with land use issues, the Beverly Hills Bar Association, and many, many other privately sponsored programs. He has a specialty in negotiating real estate transactions, advising on real estate finance and other real property issues, litigating real estate disputes, and finally, specifically on foreclosures, which is why we have him here today.
I'm going to have him introduce me all over the place.
So, ladies and gentlemen, Joe Cobert.
Yeah, and I have had the opportunity to get to know Will, and he is a great person for you to spend more time with. The more you get opportunity to see the kinds of things, the deals he's offering, the more you'll see how you can grow and take advantage of opportunities. So why are we talking about foreclosure? Hopefully it isn't because we're fearful that we're going to have a collapse. Instead, I think it's because there are opportunities and there are potential pitfalls, and we want to know that we're going to be able to be aware of them or have representatives, whether it's lawyers, brokers, whatever, that we can go to tell us about opportunities and to warn us of, what are the concerns in given properties. So I think we are in a very interesting market. I had thought, based upon the big spike in interest rates at the beginning of the year, that we might be having much more difficulty. I'm delighted to know that it hasn't happened, but there are still people who get themselves into a situation where either they haven't learned enough about the risks, or they picked a property that they just have a problem with, they're over leveraged. These kind of things can happen individually, and so it's very important for you to be sensitive to those kinds of things and to buy and sell with that in mind. So I'll start off by saying I'm going to be talking about California foreclosure law and practice. It's not the same in every state. California has its own special rules about a lot of things. We kind of been the trendsetter over the decades in real estate changes, and foreclosure is not different from that. It's a complex subject, but it's important that we understand some of the basics and then build from there. So in the first session of this seminar back in November, I addressed a number of topics. If you guys want a copy of the outline for that, we'll be able to get that to you, either contact Will or me. But I'm also going to spend a few minutes now going over the highlights of that so that you can utilize that information in our current session, which is basically strategizing how do you take advantage of the foreclosure situations that may arise. So if we look at the screen, I've laid out a few things as a start. The most important thing I think you need to know is that the laws change. They're different in different states. If you're going to invest outside of California, you need somebody to help you know what the special rules, the idiosyncrasies there. I'm delighted if you are going to invest outside of California to make recommendations of people that I would feel are good choices for you to get information from. Of course, if it's here in California, that's my niche. So we are going to deal with at the outset with 7 topics that I think we need to make sure you understand what they are and why they're important. So that's this outline, A, B, C, and on through G. So recourse versus non-recourse liability. What does that mean? Well, if you buy a property and you owe money on it, you have a mortgage, a deed of trust, can you be in a situation if the property declines or you have problems where it gets down below your purchase price and you owe more money on the obligation than the property's worth? That's one of the places where we need to do planning. It's nice if you can get a situation where that can't happen. There are laws that say when it can't happen at all, and particularly appropriate for 1 to 4 family properties. But recourse liability means if you cannot get the value when there's a foreclosure, if the lender or a buyer at a foreclosure sale pays less than what's owed on the note, and the lender isn't willing to take that as full payment, we call that a short sale or payoff, then you may be at risk for your other assets. We want to see if we can avoid that. We want to make sure that as you're looking at these choices, you're aware of that issue. Then there's a difference between a deed of trust and a mortgage. If you would go back to common law in England, they had real estate. The only way that they would have people be able to borrow was to sign documents called mortgages. And mortgages are not particularly, they're pretty cumbersome. California was smart enough to find a way to get around using them. What's a mortgage? Well, there's somebody who says, I want to borrow, and that's the person who's the mortgagor, the lender is a mortgagee, and the property is what they're talking about putting the mortgage on. Unfortunately, if you have a mortgage, then and there's a problem, you're gonna have to go through a court process to get it reconciled. Fortunately, back in the 19th century, somebody wisely in California came up with a different approach, much more expeditious and much more effective, and we use it all the time now, which is the deed of trust. And instead of 2 parties, the mortgagor and mortgagee, a deed of trust has 3 parties. The person who executes a note, or what the obligation is, and that's known as the obligor. And in deed of trust parlance, it's the trustor. And then there's the person that is a lender, and in deed of trust parlance, beneficiary. But then we have a 3rd player, which wouldn't have been involved ever in mortgages. But that 3rd player, often a title company, has the function of being able to help you facilitate a foreclosure transaction and make sure when the loan is paid off that you can get the property cleared by what we call a reconveyance. So that's the difference between the deed of trust and the mortgage. Deed of trust has a much shorter timeline. So if you're the lender on that, you're pretty inclined to do that. And if you're the borrower, you won't have as much risk of legal costs in a courtroom. Now, that ties right into the difference between judicial foreclosure and non-judicial foreclosure. Judicial foreclosure means you're going to have to go to court. There are certain instances where people would choose to do that, we'll get into, and there's certain instances where you really don't have any choice if there's a title problem or something. But most of the time, you want to be able to, if you're a lender or you're a carryback seller and take a note and deed of trust, you want to be able to go through that quickly and either get paid off or expeditiously put it up for sale. How does that work? You start a foreclosure by recording a document in the recorder's office called the notice of default, and there's a timeline. And that timeline is basically three months and 21 days. So that's a lot better than going to court, because in court you could be 3 years. The deed of trust approach says, if you owe money, we're going to give you some opportunity to cure if it's a curable thing. You know, if you didn't pay a monthly installment payment, that's something that you can cure. But if the loan is totally due and payable, you know, there is no interim cure. You're going to have to pay it off. What's the timeline? From the notice of default to the next stage, which is called the notice of trustee sale, it's 3 months. So in the interim, if you can cure a default, you got time to do it. There's also going to be the possibility that if you have another deed of trust, let's see, this is the first deed of trust and you've borrowed on a second, there'll be other players getting involved. And if you own a building, an apartment building, one of the things that many people don't understand is that there can be a situation where the tenants are affected by a foreclosure. I'll get into that in a little bit later. So those are the players potentially involved in this thing. Carryback seller, a lender, a borrower, a buyer, and maybe the tenants. Anti-deficiency rules, very complex, so I'm not going to try to go through all of that now. We probably spend an hour and a half or 2 hours in my class. But basically what it is some rules that, would you believe, came about during the Depression. And they were designed to keep mom and pop from losing their property and having money owed afterwards. We're in a different world now, but somehow the legislature has not been able to really come up with something different, so they still exist. One of them is if you carry back a loan, a note on a sale, can be a great tool if you can't, you know, otherwise make the property work, but you have to make sure that you are adequately secured, because you're not going to be able to get what we call a deficiency. So if the property isn't worth that much, you're, you know, as the seller, going to lose out. So you got to make sure that you price it right. Then there's another thing, which is that if you do go by the non-judicial foreclosure method, the faster one, and you finish the foreclosure that way, you can't go for anything more. So there are choices and pros and cons. And then you get into what would happen if why would you go into a judicial foreclosure? I said one reason might be if there's a title problem. The other is if you have an obligation, you're the lender or the seller, and you can't really wind up getting the money out, you may want to bring the lawsuit, because you can collect a deficiency on a loan if you go the court way. Yeah, it's cumbersome. Construction loans and other types of indebtedness, the same kind of thing. So you're trading, you know, the quick method, nice and easy, versus the situation where you may want to try to get additional opportunity to collect the money. If there's multiple security, somebody gives you 2 deeds of trust, you can go after one. If you don't get the money, all of that from the one, you can go after the other. So then I said there's something about tenants. Will has some apartment buildings, and fortunately he knows what he's doing. He's not likely to have a situation where he runs out of money, and so he's not going to worry about this. But there are other people out there who will, and the lenders who loan to them will look at the property and say, well, let me look at the leases, because if the loan came before the leases, the loan has what we call priority over the leases. That means, and if the leases come first, the leases can say, why is that important? Because your tenants will be affected by the foreclosure. How can the parties do something to make it so that it doesn't happen unexpectedly? and there are agreements that can be signed. So if Will goes and finances his apartment building with a lender, sophisticated lender, bank, whatever, they're going to probably say, we don't want to have a risk that the tenant's going to leave, and so we're going to have you sign something called an attornment agreement. The tenants, probably not in the least sophisticated areas, but certainly in more sophisticated commercial deals, they're going to say, well, we don't want to have a risk of being wiped out because he didn't pay his bills. What do? We ask in our leases, if we can get them, to have the lender make sure that he gets the language that says, if you're paying your rent, you're not going to get thrown out. All right. So then I also want to talk about the concept of priorities one more time. What does it mean to have priority? You've heard first trust deed, second trust deed, that kind of thing. When is it important to really understand what they do? When a foreclosure is going to occur, because the party that has the highest priority, the first trust deed, is a lot safer than the person who's second. If there's somebody who doesn't pay on the second, someone forecloses, either the lender or an outside buyer, they may be able to get the property by foreclosure, but they're still going to own on the first. By contrast, if you have a first trust deed, you know that you're not going to get eliminated or wiped out because you're in control. And in fact, you may be able, from that standpoint, to use that as leverage or to get some advantage by foreclosing and eliminating all these other deeds of trust or liens or whatever they are, which makes it attractive later than when you want to go sell the property. It's not encumbered by as much. You've put yourself in a much better position. So the concept of priority is important in that regard. Well, now let's go on and talk about how you get through a foreclosure. And it's really 3 stages. 1, when you start buying a property or taking out a loan, understand the loan documents, understand the purchase documents. If you need help in the beginning of your career, which I think probably is a good idea, I even did, and I'm a lawyer, I made sure I hired some people to give me guidance when there was stuff that I didn't know about. I didn't just assume that because there's a document that's pre-printed, it must be okay. A lot of people come to me in my legal practice because they made those assumptions and it didn't wind up being the case. They would have been much better off to have contacted me or someone else to explain these kinds of things that we were talking about. So you got to do that. Then you also got to understand the advantages and disadvantages. If you finance your property a certain way, what are the pros, what are the cons? I told you a few of them, with the difference between recourse and non-recourse, judicial and non-judicial foreclosure. What would be the possibilities on the property that you're buying or selling where these items would be important to you? So you got to identify what would be your priority position on foreclosure. Now let's go to the next phase, which is, okay, you made a loan on a piece of property, or you were a borrower, or you're a buyer and gave a carryback loan to a seller, and there's a default. Something hasn't been paid, something is you haven't performed, or your person that is your buyer supposed to keep the place up and in good condition, and when you're ready to foreclose, you find out that they really haven't done that. And if you're going to foreclose and take it back, it's not going to be what you really had hoped it would be. The deed of trust is going to say that they're supposed to do that, but people don't always do so. So what do? You look at possibilities of if you have to foreclose, or is there a possibility that you could avoid that process entirely? And sometimes you can do that by going to the borrower who's in trouble and discussing with them, why don't you just deed the property to me? I won't go through the foreclosure, and you're out, I'm in, none of that logistical headache. Why doesn't that get done all the time? A, because there often are other items on record after the first deed of trust. And if you take a deed in lieu of foreclosure, rather than do the foreclosure, you're taking the property subject to what's there. If you foreclose, you wipe those off the slate. And so the deed in lieu of foreclosure is not a slam dunk. You need to be able to find out. If you're considering it, get in conjunction with your planning, a title report, or have an attorney or someone else representing you find out what's there, so that you'll be able to say, hey, this is a time when I would do it. And I'm only going to do it if I can get title policy that says, don't worry, Joe. If the property is income producing, so you've got tenants there, and you are a lender or a carryback seller, and the buyer or borrower goes into default, well, what do? If they're going to keep collecting the rents and not pay you, you don't like that. So what can you do to, while you're waiting for the foreclosure process to run its course? Well, you can go to court and ask for the appointment of something called a receiver. A receiver is somebody who's really beholden to the court, not your puppet, but somebody who will step in and make sure that the property's kept up, that the rents are collected and kept by the lender, so that the borrower, as long as they're in default, aren't going to take the money and run. Then I say negotiations among creditors. A lot of times there's first, second, maybe a third, and each of them may look at it and say, well, I don't want to get this position. The first is in control. What can I do? Can I find a way to cure the first and get a higher position? Let's see what we can do. And so then we go into the decision of whether to use the judicial or non-judicial foreclosure. We've talked about that. If it goes by way of the non-judicial foreclosure and it's completed, then, as I said before, that's all you get. If it's by a judicial foreclosure, we have a very interesting thing. Only California would come up with it, which is you go to court, the person owes you money, you prove your case, you get a judgment that they owe you this much, and the judgment says you can have the sheriff do the equivalent of a foreclosure. Sounds good, but in a court situation, somebody can file an appeal, that drags it out. But worse yet, and one of these things that I think goes back to the concern about mom and pop in the foreclosure, in the depression, there is a deal where a party that is the object of a judicial foreclosure gets a second bite of the apple. They have something that they're allowed to say, wait a minute, I don't think the price that came about in the court situation was fair. It wasn't a really market price. People paid lower because they knew it was a court thing. And we can go out and prove that by getting an appraiser. All of this is complicated stuff, and which is one of the reasons that people really don't want to be in a judicial foreclosure, but it happens. And so what is the consequence? You've got the judgment from the court that says you are entitled to foreclose, and the sheriff is ready to, sell the property. But the court says, well, we got to do this thing. We got to give these people a chance to show whether the property is really worth more, and that they're not getting, that they're getting their full value of the foreclosure. Well, if there's going to be a deficiency, you're going to have to wait 12 months. If it's not a deficiency, 3 months. What do you think is the impact of that on someone who wants to buy the foreclosure property? You're probably not going to want to sit around waiting to know whether you really have a deal or not. And so it's one of the main reasons why we really try to avoid that. All right, but let's say that we really are all the way through the foreclosure process, and we're at what I would call the day of reckoning. The process has gone to the conclusion, and it's time to decide what to happen. You set a notice of the sale date is here, and what happens? And if you're going to be a person that wants to get involved in buying notes or bidding at foreclosure sales, this is the part that's really important for you to get to know, to have someone who you can trust that will give you advice along the way. So first, you need to find out about the property, and you can't do the same thing you would if you were buying the property, in a non-foreclosure context. You can't get a title company to insure your acquisition. So you really have to, you can get a title report and look at it, but you're taking some degree of risk. You also may have some difficulty getting a real opportunity to look through the property. So, there's a condition issue. Well, why do people then do foreclosures? Well, because if they have done enough homework that they're willing to take the risk, they often get great deals. And so people that get involved in this area of financing, have to probably learn. Sometimes you learn the hard way. You make a mistake, but if you're really good at it, the winners way outnumber the losers. Now you're at the sale itself. What happens? Well, you got to bring, if you're the party foreclosing, you get a free opportunity to wait and see what happens with everybody else. You get what we call a credit bid. Whatever is owed to you, you don't have to come up with any money unless somebody comes in with cash more than that. So you got a big opportunity, a big benefit right from the get-go. However, if the property is very valuable, there can be a bidding war and people will come in. The trustee who conducts the foreclosure will say, you got to bring cashier's checks. Coming in with a regular check, I don't want any of that. I want to see that you're qualified. So people come into these sales with lots of cashier's checks. If they don't get the property, they take them back to the bank. But if they do get the property, they are credible. And so up to the amount that's owed to the foreclosing party, that foreclosing party doesn't have to come up with any money. They have what we call a credit bid. If it goes above that, and we have an auction basically, then everybody has to bid an increased amount, which the trustee will say maybe the next bid is $10,000 more, whatever. And if it's the foreclosing party and they want to get the property, they now have to put up some money of their own over and above whatever they've bid as a credit bid. So this is an interesting dynamic, and it can be a great opportunity, but it's also an area where there's risk if you don't know what you're doing. What happens then if you are the successful bidder? If it's a non-judicial foreclosure sale, the trustee is supposed to, within 15 days after it concludes, give you a deed called the trustee's deed. That deed is basically, doesn't come with any warranties. The trustee doesn't do anything. That's like a quitclaim deed. But if you've done your homework, that's the way it works. And then you go to a title company and say, what did I buy? And can I get it insured? That sort of thing. If you do go this other route, the judicial foreclosure, I've talked about this before, then you really have to be quite careful in recognizing how long it could take and what those pitfalls are, but it can be a great opportunity as well. So these are the kind of dynamics that go on in the foreclosure process. This is just a quickie zip through it. And if you get into a situation where you're going to borrow money or have a seller carry back, get some advice, because they are things that have lots of repercussions. There are little subtle things in there. I've had situations where I knew something that the other lawyer didn't, and my client got a big advantage because we structured it, put in wording that was to our benefit, and then they said, oh my God, we didn't know that, too late. So those are the kind of things that I think are what's important to get a glimpse of in the foreclosure area. You have an outline that was on the board. You can get copies of it from us as well. And if you ever want to just, call and get some, pick my brain advice, I'll be glad as a person who's a guest at Will's seminar to do that. If you're in a situation where you need much more extensive advice, I'll be glad to help.
We will put Joe's contact information, but let me open up the floor to any questions. I know I had a question for you. I know you had like kind of a good story about like how this actually worked for you for one of your clients. Do you want to tell that story that you?
Well, I'm not sure which one it is, but there's one that I was representing a party who was buying a property and doing a wraparound. Is that the one you're thinking of? Yeah,
that's the one.
Wraparounds are a situation, we don't see much of them now, but we will if it becomes harder and harder to sell properties, because the seller will probably have to carry back paper. The buyer doesn't want to go get a very expensive loan. And so they work out a deal where the buyer pays the seller and the seller pays the lender. And it's, hoping that the lender doesn't catch on. Well, in my situation, something I identified, which the lawyer on the other side, this is a property in Texas, they didn't think about. What do you do if the underlying, the existing loan pays interest, is amortizing, and so the loan amount reduces? Who gets the benefit of that, if it's the buyer or the seller? They didn't know about it. They assumed that it would be the seller, but no, we were the buyers and we put it in that said we get the benefit. So instead of the amount that we originally said was the purchase price, which consisted of what was owed on the first and the equity, the balance, the difference that the seller was going to get, that declined. And that declined by an amount just under $100,000. Well, you can imagine the chagrin that the seller had when realized that, no, I'm not getting $1.3 million, I'm getting $1.201 million. And what he said to his lawyer, I don't know, but my client was very happy and said, that's cool, Joe. Thank you for spotting that. And we came out great on that one. So it's very good that we had your sage advice.
Very good. Very good. Are there any questions? Does anybody else have questions? Mary?
Hey, Mary.
Yes, thank you very much. Do you have any experience, or could you speak to HUD foreclosures? I found a property that potentially could be interesting for a client that's a HUD foreclosure.
Now, HUD foreclosures still have to go by the same rules of timing, but HUD has different items in their documents that give you different options along the way. I'm not really a specialist in HUD foreclosures. When I get one of those, I usually refer that to somebody who is. Yeah. Any other questions? What are you drinking there, David?
Just H2O water.
Great. So how about a question? Somebody ever run into something else heard about a foreclosure situation and want to know what happens?
Yeah, well, does anybody else have, I mean, Joe's a real estate transactional as well as litigator. So you could open this up for any real estate questions, right? Well, so like if you guys have issues with any of your deals that you're dealing with, this is a chance. I'm not going to say free legal advice because he's not here, he's not on the clock, but he is.
Well, I'm here now.
Yeah,
I'm not on the clock now.
Been here for 50 years. So it's been, he's got a wealth of knowledge. So if any of you have a deal or something that you've been through that you want to discuss, this is an opportunity really to
I have a couple of books out that deal with a lot of these things, including one that has a big chapter on foreclosure. So I know these, but I don't really have a specialty in the HUD area. So I'm sorry, I wish I could answer that question. But they have to go by the rules, the timing. But HUD has a lot of different items in there. And when as I said, when I get it, I would send that out to someone else who does that all the time. But anything else? Come on, guys.
I got a quick
free
question.
shot.
Hey, Michael.
Awesome. Thank you, gentlemen. Great information. Thank you so much. If you can just circle back around as far as on the transfer of deed, or the transfer of deed of trust.
Okay.
And kind of how
So-
that works. Awesome. Thank you.
Okay, the deed is the title that you get and you have the ownership. The deed of trust is a document that says this is security for an obligation, usually a note, and that's in favor of the creditor. So the deed of trust gets recorded in order that the world knows that you have a claim against the property and that you have the ability then to foreclose if you don't get the terms satisfied. You can sell notes and with them the deeds of trust. So if you have a situation where you've got a note and deed of trust and you want cash, you might be able to find someone in the market will buy it, usually at a discount, or vice versa. If you want to get involved in something, you might look into, and there are people that specialize in that, selling notes, and you might buy one where you can get a discount. Somebody wants to get cash today, you do some kind of an analysis, often a present value analysis of what that's worth, and then you make them an offer. And I've done that many, many times. You have to have willing parties, but if you're in the situation, you may get something that's near foreclosure. The other guy doesn't want to have to go through it, but you get a big discount. So if you do go through foreclosure, you got a winner.
So how do you find these deals, Joe? How do you find a good deal? I mean, we're all here looking for deals, right? I mean, that's why we're here.
Yeah.
So.
There are loan brokers who specialize in this.
Mhm.
There are attorneys like me who have clients and colleagues who have these things all the time. If you wanted to call and say, Joe, what do you have on, available on the market? You also have, besides the, individual people, you have some hard money people who know about all these things because they're involved in wheeling and dealing, and they don't always handle matters that are just very expensive. They find out, people come to them and say, gee, I'd like to get rid of this note, and do you know somebody who would be interested? And they have clients that buy those. So if you get into the business of buying and selling notes, that's a whole area that sometimes can be very, very profitable. And you have to know about foreclosure law in order to be effective there. Right. Other questions? Come on, one more. How about one more brave person?
Like I said, it doesn't have to be about foreclosure. It could be about anything really oriented.
If you have a deal that you've been looking at and you're puzzled about something, ask a question. I'm here to help you.
Hi, my name is Shayna.
Hi, Shayna.
Hi, I just joined the meeting kind of late. I just know I just missed a lot of gem, but I am looking at a pre-auction property. It's a hospitality property, and I only bought a few residential property before, and it's really huge, but I don't know anyone who can fund this deal.
Well, okay, an auction property, sometimes there is, and this is the same as with personal property like art, whatever it is, sometimes there's a floor that the seller is not going to let you get anything below a number, and sometimes it's not. If people really want to do that, you can bid, and if you're the successful bidder, you may be able to get something at a deep discount. You need to know by talking to the auctioneer, which is usually a real estate broker that specializes in that area. What do you got there? What is it that are going to be the terms of your auction? Can they pull it off the market, or are they once they're committed, there's a deal. There's a lot of those kind of things. If
Yeah.
you've ever been to
Mhm.
an art auction, the bidding process is a lot like that,
Right.
but real estate is kind of different. It's got things you got to look at, what's it encumbered by, what am I buying? And there again, you're not going to be able to get a title policy to ensure you at the auction. So you need to do some homework and make a decision. Are you willing to take, if you've done the homework and you feel that you can take the risk, rather than, much safer approach. I would say on your first few deals, do it the conventional way, learn about these things. If you have an auction deal that you're looking at and want some advice, call me.
Yeah, so this one, the original auction has expired. I guess whoever, bid it, they couldn't meet the reserve.
They
So
couldn't get a sale out. Yeah.
Yeah, so I showed interest before the auction date, and then the person who listed, he reached out to me and says, if you are, they're willing to sell it for $1.03 million, and I don't have this money, and I'm not sure how long they're gonna hold it for. And at this time, do you walk to the bank or, who you talk to because I'm new to this area, I don't have a network of people who can.
Well, if it didn't sell at auction, just like a property that, is listed and pull off the market, sometimes there's a good reason for it. Sometimes it just isn't, no one is interested. They're going to other things, but it gives you a possible opportunity to bid for it. And if the situation is because they took it out of auction, they're willing to entertain conventional offers for it. That's a great opportunity sometimes.
Shayna, is it Shayna or Shauna?
Shayna.
Shayna, if you're looking for lenders who could potentially work with you, it sounds like most likely they're looking for a hard money, AKA almost cash offer, right? So if you need folks, we have people we can recommend. I put my information in the chat as well as Joe's information. So feel free to reach out to either of us. Both our email and our phone numbers are in there. But yeah, generally you want to, I think, speak to a lender who specializes in these areas, who feels comfortable, lending on this type of product.
Awesome. I'll reach out to you after the meeting.
Sure.
Thank you.
Okay, guys, any further questions? I'd be delighted to answer, but you'll also get both Will and my information on the chat. And so if you think about stuff tonight, tomorrow, or anytime, feel free to call us.
Absolutely.
And participate in more of these things because Will's seminars are great.
Thank you. Thank you. Yeah, so we do these every month, and we try to do different topics. We definitely are going to do one here on property management, rent control. Mary and I are already talking about what type of topics we're going to discuss with those things. Those are always very popular whenever we do those. We'll definitely do a 1031 exchange. I have a presentation teed up right now. That's actually, I've been surprised at how popular it's been. It's called Managing Real Estate Investment Assets for Aging Adults. And the reason being because there is this generational shift happening right now, right? Where a lot of real estate's owned by the baby boomers who are now in their 70s, 80s, and 90s. And we get calls from their kids who are now in their 30s, 40s, 50s, 60s. And usually on the management side, but oftentimes trying to figure out what to do because they're stuck with mom and dad's assets and they don't know, and they're in another state, or
There are some wonderful opportunities that can be, you can get some advice from lawyers who do estate planning.
Yes.
As for saving taxes, for making sure mom and dad's stuff goes to where you want it to go, all those kinds of things. And we know people who we could recommend if you have families or people who have the need to go see that kind of stuff. I've seen structures of such complexity, whatever it is, and people save millions and millions of dollars. And so it's something worth being aware of. And again, you can call one of us and say, can you recommend somebody to me?
And I think the reason we get so many calls, we being on the TL Properties property management side, is because they often have immediate problems. And I always call it the 4 T's: tenants, termites, toilets, or taxes. those are the 4 issues that we get called for, right? Tenants, termites, toilets, or taxes. And they've got to deal with those right now, right? And then we then try to help them with all the, we forward them to people who are experts, who are estate planning experts or real estate, transactional experts or whatever it is, or a 1031 exchange accommodator or whatever it is they need, but it often ends up on our plates first because they've got an immediate need to deal with. So I'll be doing that one here shortly. I think we just attended a great presentation yesterday on like relationship agreement. I mean, he called it intimacy agreements, but it really is about like, if you're married or you're cohabitating or, you've got, you've been divorced or whatever, like all these various agreements and how that affects real estate.
It does in many ways. And I had a situation not long ago where a very wealthy doctor had a girlfriend, and unfortunately, it was one of the casualties of COVID. They stayed too much time together and they split up, but they had 2 properties that they owned 50-50. What do you do? One person said, I don't want to sell it. The other person says, I need the cash. And so there are legal remedies to deal with that as well. That doesn't necessarily have anything to do with the cohabitation aspect, but it's economic. And that's the way it works.
We're seeing this all the time. I think especially now, actually, every family law attorney that I've spoken to has been busier than ever because I think the pandemic kept people from being able to separate because they were forced to stay together. And now all those people who would have maybe gotten separated are now getting separated, as well as the regular folks, as well as the ongoing effects of what's happened with the pandemic. So these are all important issues. We always try to keep it up to date and interesting. And like I said, we always do a market update. We always do wants and needs. So if you got deals, bring them to the room. We often have buyers here. We have sellers here. We have folks who are always looking. And if there's any way we can help, let us know. Like I said, our information is in the chat. And I put the 2 deals that I mentioned also in the chat. So if you guys are interested in those, feel free to download those.
Do you also send out a periodic newsletter or something?
Yes, absolutely. And, feel free to email us to get on our newsletter list. Meetup doesn't give us your email. So we have to kind of, reach out to you guys and ask you guys to reach out to us. That's it for me. Anthony, do you want to close us out?
Yeah, no, just great job. Thank you so much for coming back a second time. If you want to see more of the first session, it's on our YouTube page at The Collective Realty. So just search The Collective Realty on YouTube and check them out, and all the other topics, especially the last one. If you weren't there last month to hear, investing in multifamily 101 and all the basics that you need to know and understand. And I think one of the more unique aspects of that class was learning like what actual good cap rates are for different areas. It's all part of that. So that's something that, you can Google what's a GRM, what's a cap rate, how to figure that out, right?
I will say that apartments are a wonderful way to invest in real estate. I started there and still have most of my real estate investments there. Look, we got a smiling face.
Yeah, so check out our last ones, and we look forward to seeing you guys next time. And we're in person and Zoom. So if you can get to West Hollywood for our next one, we always have food and drinks, and it's a good place to meet people face to face. And we'd love to see you. So Thanks, Will. Thank you so much. Have a great evening, everyone.
Thank you, guys.
Thank you.
Thank you.